The English legal system. Jury challenges. There are various challenges which may be used by the prosecution or defense to ask jurors to stand down and not serve on a particular case. These include 1. Challenge to the array. 2. Challenge for cause. 3. Standby for the Crown. Peremptory challenge used to exist, but is no longer available. 1. Challenge to the array. The defense and prosecution have the right to challenge the whole jury on the basis that it has been chosen in an unrepresentative or biased way under Section 12 of the Juries Act 1974. This was used in the Romford jury case in 1993, where 9 of the 12 jurors lived on the same estate and 2 were from the same street. In R.V. Fraser, challenge to the array was used to get a multiracial jury where the defendant was black but all jurors were white. However, in R.V. Ford it was held that there was no right to a multiracial jury. Challenge to the array could not be used simply to get a multiracial jury. 2. Challenge for cause. The defense and prosecution have the right to challenge individual jurors where they can provide a just cause for them not serving. For example, if the juror is not qualified to serve or if they know the defendant or any of the witnesses. A person cannot serve if they know someone involved in the case. In R.V. Wilson and Sprayson, a juror asked to be excused as her husband was a prison officer. The excusal was refused and she was placed on a case where the defendant was on remand in the prison where her husband worked. Their convictions were quashed as there was potential for jury bias. 3. Standby for the Crown. The prosecution, but not the defense, may ask any number of jurors to stand by without giving reason. The person asked to stand by is put to the back of the list so that they will not serve unless there are insufficient numbers to make up a full panel. Attorney General Guidelines of 2012 suggest that there should be minimal interference with random selection and the right to stand by should only be used where the juror is manifestly unsuitable. Peremptory challenge. Until 1988, the defense could challenge up to 7 jurors without giving any reason. This was then reduced to 3 and then abolished altogether. Where there was more than one defendant in a trial, they could pool their rights. This was used in the Greenham Common case 1985 to get an all-female jury and in the Bristol riots case in 1982 to get an all-black jury. Venard and Riley's research found that it was only used in 22% of trials, and the CPS research concluded that it had no significant effect on the rate of convictions. Nevertheless, it was abolished under the Criminal Justice Act 1988. In summary, the jury challenges include challenge to the array where the whole jury is dismissed, challenge for cause, where a reason is put forward for the juror to not serve, and stand by for the Crown where the prosecution can ask individual jurors to stand by without giving any reason. Peremptory challenge, a similar right of the defense, was abolished. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.